As of February 2nd, 2026, the Department of Justice isn't simply going through a rough patch. It's enduring a structural correction, one that's being mistaken for scandal when it may actually be a constitutional reversion. From the ouster of Ed Martin to the resignations in Minneapolis, from broken grand juries to broken chains of command, the DOJ appears less like a federal law enforcement agency and more like a long, overextended power center, finally collapsing under its own doctrinal weight. Let's start where the headlines are. Ed Martin, former head of the DOJ's weaponization working group, was demoted, exiled to a satellite office, and is likely on his way out altogether. Once seen as a political enforcer inside the DOJ, Martin still controls the pardon office, but has lost most operational power. This signals not just internal pushback, but a larger unraveling of the partisan machinery that's increasingly defined DOJ leadership in the second Trump administration. He may go, but the pattern remains. That pattern is visible in the exodus. More than 1/3 of the DOJ's senior career leadership has walked away since the 2024 election, and entire divisions, like civil rights, voting, and public integrity, are operating on skeleton crews. The lawyers who once ensured process, ethics, and factual integrity are being replaced with ideologically aligned appointees or political insiders. Whatever else that produces, it doesn't produce reliable prosecutions. The Comey and Letitia James cases proved that in court. Those two cases, dismissed late last year, weren't tossed because of ideology, weak evidence, or an activist judge. They were tossed because the DOJ couldn't perform basic legal functions. They appointed a prosecutor unlawfully, presented an indictment without proper grand jury review, and filed at the edge of the statute of limitations, only to trip over the deadline. The result? Cases permanently dead, no appeals, no redo, just procedural collapse so basic it read like parody, except the consequences were real. And those consequences ripple beyond DC. In Minnesota, where federal prosecutors have clashed repeatedly with local courts over immigration enforcement, civil rights, and protest policing, the system has entered open revolt. Dozens of DOJ officials resigned from the Minnesota U.S. Attorney's Office in January, citing federal overreach and disregard for local legal standards. That's not just staffing turbulence, that's mutiny. At the same time, DOJ has launched high-profile arrests of protesters, including journalists, tied to demonstrations around fatal ICE shootings. Judges in Minnesota are calling out DHS and DOJ agents for ignoring orders. State officials are being subpoenaed by federal grand juries. Body cameras are being distributed to agents to appease public outrage. And the local federal prosecutor's office has become a shell of itself. This isn't routine intergovernmental tension. It's federalism in open conflict. Meanwhile, the Civil Rights Division is being repurposed for partisan utility. Where once the department enforced desegregation orders and prosecuted hate crimes, it's now tilting toward voter fraud cases, gun rights litigation, and religious liberty enforcement, all high-priority items for the current administration's base. What civil rights work remains is ideologically filtered, then relabeled and redirected. The law hasn't changed, just its target list. What ties all of this together, from courtroom chaos to Minnesota flare-ups to career staff purges, isn't partisanship per se, it's structural exhaustion. The DOJ is doing too much, too poorly, and too far from its constitutional roots. And the founders never intended it to function this way. In fact, they designed against it. Federal criminal power was supposed to be rare, narrow, and tied directly to national interests, piracy, counterfeiting, treason, and crimes in federal jurisdictions. Everything else, that was for the states. The modern DOJ only exists in its current form because of interpretive creep. commerce clause elasticity, necessary and proper expansion, and decades of political demand for federal solutions to problems that used to be local. We didn't grow federal criminal law because the Constitution said we could. We grew it because it was convenient, and now we're watching that convenience come unglued. And that's where this chaos starts to look productive. Because when federal prosecutors can't keep a case alive, when entire divisions collapse, and when grand juries begin to doubt the legitimacy of the laws they're asked to enforce, something deeper is happening. It's not just scandal, it's constitutional friction revealing the original design underneath. The DOJ isn't just dysfunctional, it's out of bounds. And the system knows it, even if it doesn't quite say it out loud. So the right response isn't to repair the DOJ, but to retreat it, to let it return to its core, enumerated functions. Let the states resume their role as the primary engines of criminal prosecution. Let the president's pardon power shrink naturally by reducing the universe of federal crimes. Let grand juries begin to question whether the cases before them belong in federal court at all, not to sabotage, but to restore the balance the Constitution actually intended. Because the DOJ's crisis isn't just a test of administrative capacity, it's a referendum on whether federal prosecution ever belonged in half the places it currently roams. This isn't a breakdown, it's a recalibration. It's the day federalism woke up not as theory, but as defense mechanism.